side, and we'll start with the plaintiff in that regard.
Yes, Your Honor. We do have one housekeeping matter we'd like to bring to Your Honor's attention. We ask for constructive sidebars throughout today's proceedings. Since there's no way for us to approach the bench in this virtual format, we would just ask that all objection arguments be heard constructively outside the earshot of the jury.
So the way I handle that is if you ask to approach, it will be presumed to be a sidebar. If you do not ask to approach, though, it will be presumed to be an open court. Either way, the jury will obviously hear it, but if you ask to approach, I will either give you permission to approach or not, and that will be your way of having a constructive sidebar. So please do ask to approach if you wish to argue objections outside the presence of the jury, the constructive jury, as it were. Does everyone understand that?
Yes, Your Honor.
Yes, Your Honor. And Your Honor, once the defense has done any preliminary matters they need to get out of the way, we have one stipulation we'd like to bring to Your Honor's attention.
Okay. Are there any housekeeping matters from the defense?
Yes, Your Honor. To expedite today's proceedings, we would just ask that all witnesses be constructively sworn in.
All witnesses are constructively sworn.
And then for the record, pursuant to stipulation 55, witnesses will not be sequestered from today's proceedings and will be present in the courtroom during this entire trial.
That is correct.
And additionally, in compliance with pretrial orders, we have shared our demonstrative with opposing counsel. They're also in possession of a copy and no objections were raised.
All right, from the plaintiff's side, you referenced the stipulation. Anything, what stipulation is that?
Your Honor, we met with opposing counsel before trial and were able to come to an agreement as to the inadmissibility of Exhibit C, that's the police report, and all attached documents. So the stipulation would be that this document will not be admitted into evidence today.
So Exhibit C is not going into evidence?
Yes, Your Honor.
Or the diagram?
Exactly, Your Honor.
Okay.
Additionally, Your Honor, we have met and conferred with counsel. We had a motion in limine, and we have agreed that we will not, there will be no mention of Darren Ryan, the defendant's prior automobile accident.
Okay, that's fine. When that's it, then the plaintiffs have agreed to that?
Yes, Your Honor.
So then you resolve the motions in limine?
Yes, Your Honor.
All right, are we prepared to open?
Plaintiff is ready to proceed.
The
Defense is ready?
Yes, Your Honor.
All right, we'll hear from the plaintiff first.
May I proceed?
You may.
First rule of driving: keep your eyes on the road. It's a Monday night in September, and the defendant, Darren Ryan, is behind the wheel of her Ford Focus. Her hands grip tight. She's starting to sweat. She keeps checking the clock. 5:27. She's got 3 minutes. Her friend is supposed to introduce her to a potential employer, but he is leaving in 3 minutes. As she's driving, the defendant's thinking about her bills, about her rent that's about to go up, about her job hunt that hasn't gone anywhere. 5:28. She's just a few blocks away. She hopes that that employer doesn't leave. 5:29. Finally, she sees the sign for Webster Street and takes a right. 5:30. She turns onto Webster Street and she sees them. Her friend standing on the sidewalk and someone she doesn't recognize walking away. Her job, walking away. But she sees an empty parking spot right in front of them. She waves at her friend. But as the defendant's eyes are on her friend and the employer, she doesn't see the motorcycle parked between her and that spot. She doesn't see the young woman sitting on that motorcycle. And in a few minutes, that young woman will be in the back of an ambulance, unconscious.
Objection, Your Honor. This
Num-
is a bifurcated trial per stipulation 20. So any mention of injuries such as being unconscious is irrelevant and prejudicial during this time of the proceeding, which we are here to decide liability.
May I respond, Your Honor?
You may.
First, Your Honor, in this jurisdiction, objections are not permitted during opening statement. But to opposing counsel's objection, in this case, in the complaint, the plaintiff actually alleged that Carson suffered multiple injuries, and in their answer to the complaint, the defense denied these. So it's actually part of us meeting our burden, our negligence burden, to show that there was injuries, and we won't be getting into damages territory.
Yes, I understand.
Honor.
You may respond briefly.
Briefly, Your Honor, and outside the presence of the jury constructively. It is my understanding that there are objections allowed during this time of the proceeding as opposing counsel went into damages, and this phase is liability. And so I ask that that be stricken from the record.
Well, I have no objections to objections being made during opening statement if they're warranted. However, I do agree with plaintiff's counsel that the presence of damages is necessary to show liability, and so we'll overrule the objection, but we will not permit any extended discussion of the injuries of either party to the extent the defense is pressing the counterclaim. Everyone understand?
Yes, Your Honor.
All right,
Yes, Your Honor.
You may continue.
And Your Honor, may I confirm with the bailiff that my time has been paused?
Yes, your time was paused.
Thank you. May I continue, Your Honor?
We are pausing time during all objections and arguments.
Yes, Your Honor. What the defendant doesn't see is a woman sitting on that motorcycle. And in just a few minutes, she'll be in the back of an ambulance, unconscious. Now, members of the jury, I'm happy to tell you that Miss Gray survived that collision, but not without devastating injuries. Miss Gray, could you turn on your camera? This is Carson Gray. Today, you'll have the chance to meet her. You'll learn that she lives right here in Steelton. She works for a healthcare company. She'll tell you that the last thing she remembers about that night in September is the defendant's car coming right at her. She'll tell you that the next thing she remembers is waking up in the hospital. Thank you, Miss Gray. Those injuries were caused by the defendant when she rear-ended Miss Gray's motorcycle. And today, the evidence is going to show that this entire case, the reason that we're here today, is because the defendant broke the first rule of driving. Keep your eyes on the road. Now, as the plaintiff in today's case, we have the burden of proof. We have to show you it's more likely than not that it was the defendant's negligence, her carelessness, that caused Miss Gray's injuries. And today, we're going to meet that burden by proving three simple facts. First, Miss Gray was parked. Second, the defendant took her eyes off the road. And third, the defendant rear-ended Miss Gray. So let's take those one at a time. The first fact that we're going to prove today is that that motorcycle was parked. You're going to learn that back in 2017, Miss Gray went out and she bought herself a motorcycle, but she couldn't ride it right away. You'll learn she had to pass a license test first. So she lent that motorcycle to her friend, Anthony Stork. And today you'll learn that that night in September 4th of 2017, the two of them made plans for an early dinner. Mr. Stork, he parked that motorcycle in front of the restaurant. And when Miss Gray takes the stand, she'll admit that motorcycle was on. She will admit that before the two of them went in, she got on. But she'll tell you she never put that motorcycle in gear because she wasn't planning to drive. She never put on her friend's helmet because she wasn't planning to drive. Now, after this accident, the defendant said that the motorcycle was moving, that Miss Gray pulled out in front of him and cut her off. But that's not what the evidence will show. Miss Gray will testify that that motorcycle was parked. Mr. Stork will testify that motorcycle was parked. Now, the defense might say, well, Miss Gray's the plaintiff and Mr. Stork had been drinking earlier that day. And that's true. But the defendant's friend, the defense's eyewitness, she'll also take the stand today. And when she does, she'll have to admit that she did not see that motorcycle move an inch until after the defendant hit Miss Gray. That brings us to the second fact that we're going to prove today. The defendant took her eyes off the road. Now, members of the jury, you're going to learn that it was already 5:30 p.m. when the defendant turned on to Webster Street that night. You'll learn that the first parking spot she saw was right in front of a motorcycle. But you'll learn that as the defendant began to park, well, her eyes weren't on that motorcycle. They were on the sidewalk where her friend was waving and the employer was leaving. That brings us to the third fact that we're going to prove to you today. The defendant caused this accident. You'll hear from multiple eyewitnesses that after the defendant took her eyes off the road, she hit Miss Gray and her motorcycle. The evidence will show this wasn't a head-on collision. This wasn't a side swipe. No. The evidence will show that the defendant hit a parked motorcycle from behind. Members of the jury, for most traffic accidents, cases like this, it can be difficult to assign blame. It can be hard to figure out who caused a collision. But today, the evidence will show that this case is simple. Because the evidence will show that this case involves just one moving vehicle. That car was moving. That motorcycle wasn't. That's why at the end of today's trial, we'll ask you to find the defendant liable for Miss Gray's injuries because he broke the first rule of driving. Always keep your eyes on the road. Thank you for your time.
Thank you, Mr. Trevisani. Is defense ready to open?
Yes, Your Honor. May I proceed?
You may.
Let me get this straight. Carson Gray was just sitting on a parked motorcycle? That's unbelievable. What really happened on September 4th, 2017, was that the defendant, Darren Ryan, was carefully and lawfully driving down Webster Street looking for a spot when the plaintiff's motorcycle darted into the street and hit her. That is why you'll see that both the car and the plaintiff's motorcycle ended up in the middle of the road. Good evening, members of the jury. My name is Regina Rubino, and I, along with my co-counsel, Alexandra Guidarelli, we represent Darren Ryan. Unlicensed, unlawful, unbelievable. Now, the first rule of the road is not to keep your eyes on the road. The first rule of the road is to get your driver's license. Today, you'll see this is a case about the plaintiff and the decisions that she made to make sure she would have her motorcycle for her driver's exam that was scheduled for the date after the collision. This is about the decisions that Carson Gray made when she got on her motorcycle unlicensed and darted into the street and hit Darren Ryan without warning. Members of the jury, today, there are some facts that are undisputed. On September 4th, the plaintiff was unlicensed. Now, the plaintiff had a driver's license where she could legally drive cars, but she did not have a motorcycle license. Plaintiff's counsel conceded this fact to you already. And throughout today's entire trial, it will remain undisputed the plaintiff was unlicensed that day. The second fact that's undisputed is what the law of Sealton was on September 4th. It would have been unlawful for the plaintiff to get on her motorcycle without a license. It would have been unlawful for the plaintiff to get on that motorcycle without wearing a helmet. And finally, it would have been unlawful for the plaintiff to pull out of a parking spot without using a turning signal. Now, these facts are undisputed, and the evidence will show that Carson Gray did all of those things when she got on her motorcycle and darted into traffic. Now, plaintiff will present their case through two witnesses today, Carson Gray and Tony Stork. And as you listen to them testify, I want you to listen for the inconsistencies within their own story. Listen as they testify who got to Montana Max's first, who turned the motorcycle on, and whether or not the plaintiff had ever driven her motorcycle before. Now, I want to give you some more context to the story that Mr. Trevisani just told you, because there's some important facts that he did not tell you. On September 4th, the plaintiff woke up and decided to walk to work. Now, the plaintiff had a car, but instead of driving, she decided to walk that day. After work, she walked an additional 30 minutes to Montana Max's to meet up with her friend, Tony Stork. Now, Mr. Stork was the plaintiff's friend who was holding on to the plaintiff's motorcycle. Mr. Stork drove the plaintiff to her first exam, and after the plaintiff failed that first exam, she gave her motorcycle to Mr. Stork. And Mr. Stork did drive that motorcycle to Montana Max's on September 4th. But the plaintiff's second motorcycle exam was scheduled for the very next day on September 5th. Now, today I will cross-examine Mr. Stork. And as I do, I want you to listen as he testifies that he had 4 margaritas and 2 beers, all before the plaintiff met him. So it's about 5:30 when the plaintiff gets to Montana Max's and she sees Tony, she sees her motorcycle, and you'll hear that she was excited to see her motorcycle because her second road test was scheduled for the very next day. And the plaintiff needed her motorcycle to take this exam. Members of the jury, when you get to this point in the story, I want you to stop and ask yourself, what was the plan? Was it a coincidence that the plaintiff walked to work and walked to the bar? Was it a coincidence that Tony Stork just so happened to have the plaintiff's motorcycle with him that day? And was it a coincidence that by the time the plaintiff arrived, Mr. Stork was already in no condition to drive that motorcycle home? Or was it all part of a plan? A plan for the plaintiff to meet up with Mr. Stork so she could get her motorcycle and drive it home for her exam the next day. Or even if you think this is just a coincidence, when the plaintiff got to Montana Max's, she saw that Tony was in no condition to drive and she got worried. She was nervous and she darted out of that situation. Members of the jury, I can't tell you what was going on in the plaintiff's mind that day, but either way, it's the same scenario. The plaintiff was sitting unlicensed on a running motorcycle, and plaintiff wants you to believe that she was just sitting. She didn't rev the engine, she didn't put up the kickstand, and she didn't move. But today you'll learn that that story is unbelievable. Today we will call 2 witnesses. both of whom will testify that the motorcycle did in fact move, and that's how it ended up in the middle of the road. First, you'll hear from Darren Ryan. Ms. Ryan will tell you what happened on September 4th. She'll tell you it was a clear, sunny day with light traffic, and she was driving to Montana Max's to meet up with her friend, Nat Romanov. Ms. Ryan will tell you that she was slowing down on Webster Street, and she began to look for a spot when she noticed Ms. Romanov out of the corner of her eye. And at that moment, the plaintiff's motorcycle darted out into the street and hit her. Now, plaintiff's entire case rests upon the fact that Darren Ryan was distracted, that she was waving, and that she was in a rush to meet up with this alleged employer. But Darren Ryan will tell you herself, she wasn't in a rush. She wasn't distracted. And you'll hear that she didn't even care about this meeting with this alleged employer. Ms. Ryan will tell you that she was slowing down, getting ready to park when a motorcycle darted into the street and hit her. And most importantly, Ms. Ryan will tell you that she did not hit a parked motorcycle, and that after the collision, the motorcycle didn't end up in the spot in front of where it was parked, and it didn't end up on the sidewalk, and it didn't hit Tony Stork, who you'll learn was standing right next to it. Both the car and the motorcycle ended up in the middle of the road. And this will all be confirmed by our second witness, Nat Romanov. Ms. Romanov will tell you what she saw from outside of Montana Max's. Now, Ms. Romanov didn't actually see the contact of the vehicles, and we are not disputing that because Ms. Romanov was turned around. But what she did see was Darren Ryan's car slowing down on Webster Street. The car then went by her, and Ms. Romanov heard a loud revving noise, followed by the screeching of tires. When Ms. Romanov turned around, she saw not only Darren Ryan's car, but now a motorcycle in the middle of the road. Members of the jury, today I want you to keep one question in mind. If Darren Ryan really hit a parked motorcycle, then how did the motorcycle get from a parking spot into the middle of the road? Today, you will see that there is only one answer to that question. And the answer is that Carson Gray was the driver who was negligent. Carson Gray breached her duty of care and Steelton traffic laws when she got on a running motorcycle, unlicensed, and darted into the street to hit Darren Ryan. That is why Darren Ryan is asserting a counterclaim for her own injuries that resulted from the plaintiff's negligence. Today, you will see that both the car and the motorcycle ended up in the middle of the road because the point of collision was in the middle of the road, not in the parking lots. Find that the person who was negligent was the plaintiff, Carson Gray, and not my client, Darren Ryan. Thank you.
Thank you, Ms. Rubino. Are the plaintiffs ready to call their first witness?
Yes, Your Honor. The plaintiff called Carson Gray.
Mr. Gray or Ms. Gray? Mr. Gray.
It's Miss Gray there, Your Honor.
Ms. Gray, yes.
Should I
You
swear the
can-
witness?
The witness is, you may swear the witness.
Okay. Raise your right hand. Do you affirm the testimony you are about to give is the truth and nothing but the truth?
Yes, I do.
All right, Mr. Eyers, you may proceed.
Thank you. Good afternoon.
Good afternoon.
Can you see and hear me okay?
Yes, I can. Thank you.
Please introduce yourself to the jury.
Hi, my name is Carson Gray.
Where do you live, Miss Gray?
Right here, Steelton.
What do you do for a living?
I do advertising for a healthcare website. It's sort of like WebMD. You type in your symptoms and it tells you what the issue might be.
Miss Gray, why did you bring this lawsuit?
Well, 3 years ago, I was hit by a car. I was hurt pretty bad.
Who was the driver of that car?
Darren Ryan.
Without going into too much detail, can you just summarize your injuries for the jury?
Both my legs were broken.
Objection. Constructively outside the presence of the jury, Your Honor. This is a bifurcated trial as per stipulation 22, and I believe Your Honor has already ruled that mention of injury is acceptable. However, any mention of any detail of said injury is improper.
Mr. Eyers,
Your Honor, this is the only question that I planned on asking, and I specifically asked this witness not to go into detail. She told us a single injury that she had, and that's enough for us to prove damages for this liability portion of the trial, and we're ready to move forward from here.
all right, so we'll overrule it, but the same rules will apply with regard to the counterclaim. You can continue.
Ms. Gray, let's talk about the day of the accident. When was it?
September 4th, 2017. It was a Monday.
What time of day?
It was after I got off work, around 5:30, 6 o'clock.
And where were you?
I was in the Penn Woods district on Webster Street,
What were you doing there?
meeting up with my friend Tony.
Well, who got there first? You or your friend Tony?
I did.
Objection. Form.
Overruled.
Ms. Gray, who arrived first? You or your friend Tony?
I did. Tony pulled up a couple minutes later on my motorcycle.
What was your friend doing on your motorcycle?
I bought the motorcycle about a month before when I got a bonus at work, but I didn't have my license yet, so I was letting Tony use the bike since he already had his license.
Okay, so your friend pulls up on your motorcycle. What happened next?
He just parked the motorcycle and hopped off. We were going to walk to a bar.
Did you go to the bar straight away?
No, I sat on the bike for a minute.
Why did you sit on the bike, Miss Gray?
My driver's test was the next day. I wanted to sit on my bike, feel it while it was running.
Were you wearing a helmet?
No,
Why not?
because I wasn't going to ride the motorcycle. I was just going to sit on it.
You said that you wanted to feel the bike while it was running. Was the engine on?
Yes, but it wasn't in gear.
What does that mean, not in gear?
It means you can't go anywhere. It's like when a car is in park.
Now, in their opening statement, the defense, they claimed that you drove that motorcycle out onto Webster Street. Is that true?
No, I never took it out of park.
Okay, so you're sitting on the bike, the engine's on, but it's parked. What happened next?
Tony and we're just talking. All of a sudden, Tony points behind me and yells, "Hey."
What did you do?
I looked behind me.
Can you tell the jury what you saw?
A car. It was coming right at me.
If you had a picture of Webster Street, would you be able to show us where you were and where that car was when you turned around?
I could do that.
Your Honor, may this witness share her screen in order to make use of a demonstrative? In accordance with local rules, we showed it to opposing counsel before trial.
Any objection?
No, Your Honor.
All right, then yes, Ms. Gray may.
Ms. Gray, if you could share your screen.
Sure.
Now, is this an accurate depiction of Webster Street?
Yes, just a regular city street, sidewalks on both sides of the road.
How many lanes does Webster Street have?
It has 2 lanes, one going in each direction.
We're going to put some symbols up on the side of that picture. Let me know when you see them.
I see them.
What are they?
There's a car and a motorcycle.
You said that when your friend arrived, he pulled up and parked the motorcycle. Could you put that symbol that says motorcycle onto the picture to show where that motorcycle was originally parked?
Yes, I could do that. Oh, sorry about that. It was here, next to the curb and facing forward.
And when you got onto the motorcycle, where was it?
Same place.
When your friend shouted and you turned around and saw that car coming towards you, where was the motorcycle?
Same place, parked on the side of the road.
Next, could you take that car symbol and place that onto the diagram to show us where that car was when you turned around and saw it?
Yes. It was here, coming right at me.
Your Honor, may we mark this as Plaintiff's Exhibit 1 and preserve it for demonstrative use during closing argument?
Any objection to that?
No, Your Honor.
You may.
Ms. Gray, you can stop sharing your screen now. So you turn around and you see that car coming towards you. What did you do?
I didn't have time to do anything. It was moving too fast.
What's the next thing that you remember?
Waking up in a hospital.
Thank you. I have no further questions at this time.
Cross-examination?
Yes, Your Honor, may I proceed?
You may.
Ms. Gray, can you hear me okay?
Yes, I can.
Great. This motorcycle that you talked about on direct, you bought that motorcycle before you even took your first licensing exam, correct?
Yes, I had gotten a bonus from work, so I went ahead and bought the motorcycle.
So you bought that motorcycle before you had a motorcycle license.
Yeah, that's why I lent it to Tony so he could use it since he already has his license.
And your first road test, your motorcycle road test you took, you actually failed, correct?
Yeah, I missed it by a point.
And that first exam you failed by just 1 point. You used that motorcycle that you bought without a license, correct?
To take the test, yeah.
And before you took that first exam, you never drove your motorcycle.
Yes, before the first test, I did not drive my motorcycle.
So just to be clear, you went into your first motorcycle licensing exam without ever having ridden a motorcycle before?
I didn't drive my motorcycle before the first test, yes.
So that's a yes to my question. You went into your first motorcycle licensing exam without ever having ridden a motorcycle before.
Yes.
And after you had failed that first exam by 1 point, you said you gave your motorcycle to Mr. Stork.
Yeah, I lent it to him so somebody could get some use out of it until I passed my test.
And Mr. Stork is the only person that you allowed to ride your motorcycle, correct?
Yeah, I lent it to Tony. I don't think he lent it to anybody else.
All right, so Mr. Stork had your motorcycle from the time you failed your first exam to September 4th when you met him at Montana Max's.
Yes, he was keeping it till after I passed my test.
And from the time Mr. Stork was keeping it, from the time you failed to September 4th, again, you never drove that motorcycle.
Oh, I'm sure I practiced.
So you have driven your motorcycle before your second licensing exam?
I never took it out on the streets, but I'm sure I practiced at some point.
So you had practiced on your motorcycle, so you had driven your motorcycle unlicensed.
Yeah, to practice in like parking lots.
So in those parking lots, you got on your motorcycle, put the bike into gear and drove, correct?
Yeah, to practice for my test since I had failed the first one, unfortunately.
And driving in that parking lot on your motorcycle, again, you were unlicensed?
Yeah.
And you were practicing for your next exam, which was September 5th, correct?
Yeah, my next exam was on September 5th. That sounds right.
Now on September 4th, the day before your next exam, you decided to meet Mr. Stork at Montana Max's.
Yeah, we were meeting at Montana Max's after work just to hang out.
You testified that you did have work that day, correct?
Yeah, I did.
And on September 4th, you owned a car, correct?
Yes.
And instead of driving that car to work, you decided to walk to work.
No, I drove my car to work.
So but you did walk to Montana Max's, correct?
Yeah, it's about a 30-minute walk. So I walked to the restaurant to meet Tony.
So you leave your car at work, you walk 30 minutes, and then you meet up with Mr. Stork, correct?
Yeah, that sounds about right. 30-minute walk to Montana Max's from work.
So just to be clear, you were then going to leave Montana Max's, walk those 30 minutes back to pick up your vehicle at work.
Yeah.
Okay. So after work, you walk those 30 minutes and you meet up with Miss Stork, who wasn't working that day, correct?
I don't recall, but yes, we were meeting at Montana Max's that day.
But you did work with Mr. Stork, correct?
Yes.
So
Yeah.
you do know that he was not working that day, correct?
I don't recall, but we do work together. And yes, we were meeting at Montana Max's that day.
And September 4th, it was a Labor Day, correct?
Yes.
So it was a company holiday, correct?
I was working that day.
Right, but Mr. Stork was not working that day, correct?
Like I said, I don't recall.
So you don't recall whether or not you were at work with Mr. Stork the date of September 4th?
I was walking to meet him at Montana Max's.
So if you're walking to meet him, you didn't work together, correct?
That sounds right. Sure.
So after you walk these 30 minutes and you get to Montana Max's, you see that Mr. Stork has your motorcycle with him.
No, I waited for him when I got to Montana Max's.
So you actually got to Montana Max's before Mr. Stork.
Yeah, he pulled up on my motorcycle.
So while you're standing, waiting out front, you see Mr. Stork pull up on your motorcycle.
Yes.
So to be clear, you physically watched Mr. Stork pull up and you watch him park your motorcycle in front of Montana Max's.
Right. Yeah, I saw Tony pull up on my motorcycle. Yes.
So if Mr. Stork gets up here and testifies that he was actually at Montana Max's hours before you got there, you wouldn't agree with him.
I'm telling you what I remember. I remember Tony pulling up on my motorcycle. Yeah.
If Mr. Stork testifies that he actually got to Montana Max's before you did, you wouldn't agree with him.
Sure. I saw Tony pull up on my motorcycle. Yeah.
Because you got there first, you watched Mr. Stork pull up and he puts the kickstand down, correct?
I don't recall that particular detail.
But you do watch him pull up and you said he hops off the motorcycle.
Yeah.
And at that time, you noticed that Mr. Stork had been drinking.
No.
It didn't look to you like Mr. Stork had had a few drinks?
No, I didn't notice that.
Okay. But after you watched Mr. Stork pull up and hop off the motorcycle, you wanted to get on your motorcycle, right?
Yeah, my test was the next day. I wanted to feel my motorcycle while it was running.
So you got on your motorcycle because you said on direct, you had your driver's test the next day and you wanted to feel it while it was running, right?
Right.
You wanted to mentally prepare.
Yeah, I wanted to feel my bike while it was running since my test was the next day.
And you mentioned that it's running. When you got on this running motorcycle, you didn't put on a helmet, correct?
No.
But that motorcycle was running because you turned it on.
It was on at the time that Miss Ryan hit me with her car. I don't remember if it was me or Tony who turned on the motorcycle.
So that motorcycle was running because Mr. Stork turned it on.
Like I said, I know it was on at the time that Miss Ryan hit me with her car. I don't remember if it was me or Tony who turned it on.
Ms. Gray, I'm not asking you about the time after you got on the motorcycle. I'm asking you whether or not you got on the motorcycle and it was running because Mr. Stork turned it on. Yes, sir.
Objection asked and answered. This witness has already testified that she doesn't remember who turned it on, but that she got on and then it was running when she was hit.
Overruled.
Right. I don't remember if it was me or Tony who turned it on.
So then since you don't remember, if Mr. Stork gets up here and testifies that you turned the motorcycle on, you'd be surprised and you wouldn't agree with him.
No, that's not true. I just don't remember.
Okay. But what you do remember is you got on this motorcycle for motivation for your exam the next day.
Yeah, my test was the next day. I wanted to feel my bike while I was running.
So you get on this bike, the running bike, and the kickstand's down, correct?
Yeah,
And motorcycles tilt when they're leaning on their kickstands.
they can.
So now as you sat, you didn't kick the kickstand up and shift your motorcycle upright.
No,
So you were sitting on a running motorcycle that was just tilted to one side.
yes, my kickstand was down.
Okay. And as you're sitting tilted, thinking about the next day in your exam, you decide to put your hands on the handlebars.
Yeah, I'm sitting on my bike. It's not like I'm on my side like this really. But yeah, my hands were on the handlebars and I'm just sitting on my bike.
Now, with your hands on the handlebars, sitting tilted, you're thinking about what it'd be like to get out on the road.
Yeah,
And you testified on direct examination that at this time, Mr. Stork said, "Hey," right?
yeah, we were talking and I heard him yell something and I looked behind me to see what he was talking about.
He actually yelled, "Hey, what are you doing?"
Right, that's why I looked behind me.
So you're sitting, Tony says, "Hey, what are you doing?" And you turn around, right?
Yeah, that's when I saw the car coming toward me.
And just to be clear, Mr. Stork didn't say, "Watch out, Carson."
No, he said, "Hey, what are you doing?" So I was wondering what he was talking about. I turned around.
So he didn't say, "Carson, get out of the way," right?
Right.
Now I want to talk to you about what you drew on direct examination. Permission to republish Plaintiff's Exhibit 1.
You may.
To be clear, where you drew these boxes, this is not the end location of the vehicles, correct?
This is where I was when Miss Ryan hit me with her car.
Ms. Gray, I'm not asking about that. I'm asking whether or not this is not the end location. This is not the end location of your motorcycle, and it's not, correct?
Yeah, that sounds right. After I got hit, I was unconscious, so I didn't see where they ended up.
But your motorcycle did end up in the road.
That's what I've heard, but like I said, after I got hit, I was unconscious, and the next thing I remember was waking up in a hospital. So I don't know where they found me.
My question was just a little bit more specific than that, and it was whether or not your motorcycle ended up in the road. Yes or no?
That's what I've
Objection,
heard.
lack of foundation for how this witness would know this. She's already testified that she blacked out after she was hit.
Well, I don't know whether she knows it or not, so let's let her answer the question. She could learn about it a wide variety of ways, even though she doesn't remember the collision.
So Ms. Gray, your motorcycle ended up in the road, correct?
That's what I've heard. Yeah, that's where they found me.
But so you don't know where you're withdrawn. So it's your testimony today that as you're sitting on this running motorcycle, you had no intention to drive, correct?
Correct.
But your motorcycle after the collision ended up in the middle of the road, correct?
That's what I've heard. Yeah.
Nothing further, Your Honor.
Redirect?
No redirect, Your Honor. May this witness step down?
Yes, she may. Do the plaintiffs have a second witness?
Yes, Your Honor. At this time, the plaintiffs call Anthony Stork to the stand.
Mr. Stork, step forward. The bailiff will swear you. Madam Bailiff, you're muted. as they say in the Zoom world.
Sorry. Raise your right hand. Do you affirm the testimony you are about to give is the truth and nothing but the truth?
I do.
May I proceed?
You may, Mr. Trevisani.
Good afternoon.
Good afternoon.
Could you introduce yourself to the members of the jury?
Of course. Hello, my name is Anthony Stork.
Where do you live, sir?
Here in Steelton. I've lived here for about 10 years now.
What do you do for work?
I'm a bartender.
Do you know the plaintiff in this case, Carson Gray?
Yes, we're old friends. We've known each other since middle school.
I want to start back at the beginning. What were you doing on September 4th of 2017, sir?
I spent the afternoon at Montana Max's. Carson and I were going to be meeting up later that evening.
Okay, so drawing your attention to the beginning of that day, how did you get to Montana Max's?
I drove Carson's motorcycle. She was letting me drive it until she was able to get her motorcycle license.
Now, I want to be upfront with the members of the jury, sir. While you were at the restaurant, did you have anything to drink?
Yes, I had 3 or 4 margaritas and a couple Coronas.
Over how long of a time period are we talking about here?
About 3 hours.
Did you have anything to eat during that time?
Yes, I did. Max's has dollar tacos on Mondays, so I think I had about 5 or 6 of those.
So by the time you met up with Miss Gray, how were you feeling that day?
I was buzzed, nothing more.
All right, so when you met with Miss Gray, where exactly did you meet her?
We met outside the restaurant.
When the two of you met, what did you do?
It was a really nice day outside. So we chatted a while. Carson sat on her motorcycle while we talked.
Was the engine on?
Yes, it was.
Did you see Miss Gray ever start to drive that motorcycle into the road, sir?
No, absolutely not.
Okay, so the two of you are there on Webster Street, catching up. What happens next?
We're talking, we're catching up. She's sitting on her motorcycle. And all of a sudden, I see this car start coming down the road. And it gets closer. And it starts to swerve towards the curb.
And then?
It pulls right into Carson. It was really bad.
Mr. Stork, if you had a diagram, a picture of Webster Street, do you think you could show the members of the jury how that car was moving?
I could.
Your Honor, may we make use of a demonstrative aid similar to the first? In accordance with local rules, we've shown this to opposing counsel.
Any objections from the defense?
No objection, Your Honor.
You may proceed then.
Okay, Mr. Stork, you can share your screen. All right, so this area that you see on your screen, does this accurately depict Webster Street?
Yes, it does.
And we've placed a few symbols on the side of the screen here. Do you see those, sir?
I do see them, yes.
What are they?
I see a black box labeled car. I see a gray rectangle labeled motorcycle. And I see a green circle with my initials on it.
Well, then let's start with your location, sir. Could you drag that circle onto the screen and show us where you were standing at the time of the accident?
Yes. I was standing on the sidewalk off the street.
And now the motorcycle. Can you drag that onto the screen and show us where Miss Gray was parked at the time of the accident?
Yes. The motorcycle was parked on the side of Webster Street, facing me.
Finally, that car. Can you show us where the car was when you first saw it on Webster Street, sir?
Yes. When I first saw the car on Webster Street, it was just started driving down the street, headed towards us.
And now, sir, if you could show us how that car was moving from your perspective.
The car drove down the street, and then it swerved, and then it pulled straight into Carson.
Your Honor, may the record reflect that this witness has indicated that the car struck the plaintiff from the back left direction?
Well, from the demonstrative, that is what it appears to be. I don't know that the witness has actually indicated that yet, however.
Yes, Your Honor. May we preserve this as the witness has placed it for use in closing argument as a demonstrative aid?
You may.
Okay, Mr. Stork, you can close that. Thank you. So far, we've been talking a lot about the car that hit Miss Gray, but now I want to ask about the person who was driving it. Were you able to see the driver of that car clearly?
I was, yes.
How do you know that?
When we were outside, it was still light out. So I was able to see into the car as it got closer.
What did you see?
The driver was waving.
And sir, can you show the members of the jury what you mean by that? Waving?
Sure, I meant the driver had their hand off the wheel in the air, and they were waving it.
Now, when this driver took their hand off the wheel and started waving it, did that happen before or after the defendant swerved towards Miss Gray?
Before. First, the car is coming down the road. Then the driver starts waving. And then the car pulled right into Carson.
Thank you, Mr. Stork. Your Honor, we have no further questions at this time.
All right, cross-examination,
Yes, Your Honor, may I proceed?
you may.
Mr. Stork, the motorcycle that you drove to Montana Max's on September 4th, that was the plaintiff's motorcycle, correct?
Yeah, it was Carson's motorcycle that she lent to me.
Right, and this was the same motorcycle that the plaintiff used for her first exam.
Yes,
And after she failed that first exam, she then gave you the motorcycle, right?
yes, she wanted me to get some use out of it while she was getting ready to take her second exam.
And so this was the same motorcycle, since you said it was a plaintiff's motorcycle, that she was going to use for her second exam that was scheduled for September 5th.
That's right. It was her motorcycle.
Right. And so you've had the motorcycle from the time that she failed her first exam until September 4th, right?
Yeah, I drove that motorcycle until it was destroyed in the collision.
Mr. Stork, I didn't ask about the collision. I just asked whether or not you were in possession of the motorcycle from the time the plaintiff failed her first exam until September 4th, and you were, correct?
I was in possession of the motorcycle. I was allowed to drive it until it was destroyed, until it was no longer able to be ridden.
Mr. Stork, I understand that your attorneys have coached you to continuously talk about the collision.
Objection,
However, I'm just
Your Honor.
asking,
Argumentative.
Sustained.
yeah.
co-
Mr. Stork, we can,
To be clear, the inference that he was coached is argumentative.
yes, Your Honor. Mr. Stork, we can agree that you were in possession of the plaintiff's motorcycle from the time that she failed her first exam until September 4th, correct?
Right. That was the day I no longer had the motorcycle.
Right. Now, during the time that you've had this motorcycle, you weren't the only one to drive it.
Right. I would drive it like to and from work and stuff like that. And then Carson, she'd practice in the parking lot with it after work.
So, Mr. Stork, it's your testimony that the plaintiff had actually practiced in parking lots, correct?
Absolutely. In the parking lot for where we worked.
Now, during these practices, the motorcycle got there because you drove it there, right?
Right, I had driven the motorcycle to work, and then Carson would practice after work.
Now, during these practices, you actually watched as the plaintiff got on a running motorcycle, put it into gear, and drove, correct?
Sometimes she would turn it on herself. But yes, that's what happened.
So you actually watched the plaintiff drive the motorcycle while she practiced, correct?
Yeah, she would drive it like practicing the maneuvers for her test.
And during these practices, the plaintiff was unlicensed, correct?
Right, she was practicing for the test, so she could be licensed.
Mr. Stork, I just need a yes or no. During these practices, the plaintiff was unlicensed.
Right, didn't have the test passed yet.
Now, you also drove the plaintiff's motorcycle to Montana Max's on September 4th, and that was Labor Day.
Yes, I drove yes to both those questions. It was, I drove from my home to Montana Max's, and it was also Labor Day that day.
Mr. Stork, just moving forward, I'm just going to need a yes or no answer. I don't really need an explanation. It's just whether or not that was Labor Day, and it was, yes?
I'm so sorry. I thought there were two questions there, and both of them were yes.
Okay. So you had off from work because it was a holiday, right?
I didn't have to go into work that day. That's right.
And now you got to Montana Max's around 3 or 4.
Yeah, I would say that's about right.
And the bar had some Mexican Monday specials that day.
Yes, margaritas and dollar tacos.
Right. And one of the specials was a $3 margarita, yes?
Yes.
And while you were at Montana Max's, you had, as you said on direct, you had 3 or 4 margaritas, correct?
Yes.
And you can't remember specifically how many margaritas you had.
No, it was 3 or 4.
And after the 3 or 4 margaritas, you then had some beers, yes?
Yeah, I had 2 Coronas.
So just to clarify, you had 3 or 4 margaritas followed by the 2 Coronas, correct?
Yeah, over the time I was there, and the 5 or 6 tacos.
Right, Mr. Stork, I didn't ask what you ate. I just asked what you drank, and that was the 3 or 4 margaritas and the 2 Coronas.
Yes, those are the drinks I had.
And you had all of those drinks before the plaintiff met you, correct?
Yes, I had all those before we met outside.
And so at that point, after the 5 or 6 drinks, you weren't going to drive the motorcycle, correct?
No, I wasn't going to drive the motorcycle. I didn't think that was a good idea.
Now, earlier that day, you actually called the plaintiff to meet you at Montana Max's the day before her road test.
That was the day before her road test, and we decided to meet there that day. Yes?
So that's a yes.
Yes.
And the plaintiff happened to walk to meet you the day before her road test, correct?
Yeah, she walked to Montana Max's from where we worked.
And you just so happened to bring her motorcycle with you the day before the plaintiff's motorcycle, yes?
I drove it there. That's how I got there. Yes.
So that's a yes, Mr. Stork.
Yeah, that's how I got there. I drove.
Yeah. And you drove the plaintiff's motorcycle, yes?
Yes.
Now, Mr. Stork, we can agree that you got to Montana Max's before the plaintiff.
Yes.
You parked the motorcycle, turned it off, and then you went into the bar to have some drinks, correct?
Yes, I did all those things. I parked the motorcycle, then I went inside Montana Max's.
Mr. Stork, I'm a bit confused because you remember when my co-counsel asked the plaintiff about who arrived first.
I remember that, yeah.
And so you heard when the plaintiff testified under oath that she actually watched you pull up on her motorcycle when she arrived. Do you remember
I
that?
heard her say that, yes.
And that would have been impossible for her to see that, right?
It's just not what I remember.
Because you weren't driving the motorcycle at that point because you were at the bar drinking, correct?
I was at a table and I was eating tacos and drinking margaritas, yes.
Mr. Stork, we can agree that it's a fact that you did not pull up on the motorcycle when the plaintiff arrived, correct?
That's right. I got there before her.
So when the plaintiff said that she actually watched you pull up in front of Montana Max's when she arrived, that wasn't true.
That's not what I remember. That's all I can say.
Now, you also weren't sitting on a running motorcycle when the plaintiff arrived either, correct?
No, I was not. I was inside.
Right. And the motorcycle had been parked and turned off because, as you said, you were inside.
Yes, I was inside.
Now, once the plaintiff met you, you walked outside of the bar to meet her.
Yes. Yes, I did.
And the plaintiff then got on the motorcycle and she turned the ignition on, correct?
Yes, she did.
So the plaintiff actually took the keys, put them in the ignition, and turned that motorcycle on, correct?
Yes, she wanted to feel the motorcycle running the day before her test.
So, Mr. Stork, when the plaintiff testified today under oath that she didn't remember if the motorcycle was running or not, that's inconsistent with your testimony that she actually turned it on, correct?
That doesn't sound inconsistent at all.
Mr. Stork, it's your testimony that the plaintiff turned the motorcycle on, correct?
Objection asked and answered at this point, Your Honor.
We'll let it go a little further. Overruled.
Mr. Stork, it's your testimony that the plaintiff actually turned the motorcycle on, correct?
Yes.
And you remember when the plaintiff testified under oath today that she didn't remember if she turned that ignition on. Do you remember that?
Yeah, I remember she told us she didn't remember who turned it on.
So we can agree that it's a possibility that she could have turned that motorcycle on, correct?
She turned the motorcycle on. I saw her do it.
Right. Now, after you had the 6 drinks and after the plaintiff met you outside and turned the motorcycle on, you actually saw where the vehicles ended up after they collided, correct?
Yeah, after the collision, I saw, yeah, it was a really, really bad collision. Yes.
Mr. Stork, I didn't ask about the collision. I just asked whether or not you saw the end location of the vehicles, and you did, correct?
Yeah, I saw what happened after.
Now, permission to republish plaintiff's exhibit B.
You may.
Now, Mr. Stork, so this is the demonstrative that you drew today in court, correct?
Yeah, this is how I saw Carson get hit. Yeah.
Now, this is not the end location of the vehicles, correct?
No, this is where the impact happened, and just before it, the vehicles weren't there exactly when everything was said and done.
Right. So, Mr. Stork, before the collision, the motorcycle was in a parking spot, correct?
Yeah, it was parallel parked on the side of Webster Street before the collision.
Right. And we can agree that this was on the side of the street, correct?
Yeah, that's where the collision happened. The bike was on the side of the street and the car pulled into it.
Right. And we can agree that this is, again, not the end location of the vehicles.
Right. We can agree that this is how the impact happened.
So once after the collision, the motorcycle actually didn't end up in this spot as we are looking at it now, correct?
No, when the car ran into the motorcycle didn't stay put. It moved.
Right. And it didn't end up on the sidewalk, did it?
No, it ended up in the street. Carson too.
And so we can agree that after the collision, the motorcycle ended up in the road, correct?
Yeah, the motorcycle it stayed in the road after the car hit it.
Yes, Mr. Stork. No further questions, Your Honor. Permission to deconstruct.
You may. Redirect.
No further questions.
Thank you. Redirect.
Yes, Your Honor. Mr. Stork, the defense just asked you about whether or not Miss Gray drove without a license. So I want to be clear. Did you ever see her drive without her license on a road or a street?
Never. No. The only times I saw her drive the motorcycle was in the parking lot practicing for her test.
Thank you, Mr. Stork. Your Honor, we have nothing further for this witness. May he be excused?
He may.
And with that, Your Honor, the plaintiff rests our case in chief.
All right, thank you. Is the defense ready to proceed?
Your Honor, before we proceed, we do have a motion for the court's consideration.
Okay.
Your Honor, at this time, defense moves for a judgment as a matter of law pursuant to Rule 50 of the Federal Rules of Civil Procedure. Plaintiffs have failed to offer a legally sufficient evidentiary basis from which a reasonable jury can find that Darren Ryan was negligent for the collision that occurred on September 4th. Plaintiffs failed to establish that the defendant breached her duty while driving her vehicle on September 4th. The only evidence that has been proffered by either witness was merely that a collision had occurred. There's only one eyewitness presented today, and it's been established that that witness had been heavily drinking during the time of the incident. There has been no expert witness called by the plaintiff to prove causation. No evidence was presented that the defendant was a proximate cause of the injuries that were sustained by the plaintiff. Ultimately, there's insufficient evidence presented by plaintiff to establish negligence on the part of my client, and so we respectfully move for judgment as a matter of law.
Response from the plaintiffs?
Yes, Your Honor. The motion should be denied because under a Rule 50 of the Federal Rules of Civil Procedure, a reasonable jury viewing the evidence in the light most favorable to the plaintiff here could absolutely find that we've met our burden. First, we've shown duty. The defendant, like any one of us operating a car, had a duty to every person on the road. Second, we've shown negligence. Two witnesses have testified today that the defendant drove into a parked motorcycle. And third, Your Honor, we've shown causation. As a result of that collision, Miss Gray suffered serious physical injuries that she told us she broke both of her legs. All of the issues raised by defense are issues of weight and credibility, and as such, this case should go to the jury.
I think there is evidence that the plaintiff was stationary on a bicycle, on a motorcycle, and that the defendant hit the stationary motorcycle. I agree there may be evidence to the contrary, but since there is evidence supporting plaintiff's case on all elements of negligence, I'll deny the motion pursuant to Rule 50. Is the defense ready to proceed?
Yes, Your Honor.
You may call your first witness.
At this time, the defense calls Darren Ryan to the stand.
Mr. Ryan, please raise your right hand. Do you affirm the testimony you are about to give is the truth and nothing but the truth?
I do.
All right, Ms. Ryan, you're under oath and you can begin, counsel.
At this point, I think everyone knows who you are, but can you please introduce yourself to the members of the jury?
Yeah, of course. My name is Darren Ryan.
Ms. Ryan, where do you currently live?
I live here in Steelton with my grandmother. I've been taking care of her, so I've been staying here.
And how long have you lived in Steelton?
My whole life. I moved away for college, but I came back here to stay with my grandmother.
Now, Ms. Ryan, we've already heard from plaintiff's witnesses, so I just want to jump right into it. We can agree that you and Miss Gray collided on September 4th, 2017?
Yeah, we collided, but it was honestly only just when the motorcycle just darted out in front of me, and I just couldn't stop in time. I tried.
All right, Ms. Ryan, let's go back to that day. What were you doing the afternoon of September 4th, 2017?
It was a pretty normal afternoon. I didn't have school because it was Labor Day, so I was just going to go hang out with a couple of my friends at Montana Max's. One of them was my friend Nat.
Who is Nat?
So Nat, we've been friends. We actually lived together in college for a few years, and we've been friends since then.
And why were you meeting Nat at Montana Max's?
Nat mentioned that she wanted me to meet this friend of hers about a job, but I wasn't really interested in a job, so I was just mainly going to hang out with everyone.
Why weren't you interested in a job?
Well, I was still in school and I was taking care of my grandmother, so it was just a lot to handle, so I wasn't necessarily interested in the idea of working too.
That's understandable. What time were you supposed to meet Nat?
Well, Nat said 5, but I didn't take it as a hard 5 since we were just hanging out.
So what time did you actually end up getting there?
5:30, around then.
And where is Montana Max's located?
It's on Webster Street in Steelton.
And how did you get to Montana Max's?
I drove my car.
All right, I want to talk a little bit about that drive. What was the weather like on September 4th?
It was a clear day, pretty sunny for Labor Day, actually.
And what was traffic like?
It was lighter than normal. There were definitely some spots open in front of Montana Max's, which there normally isn't. I was kind of surprised. It's usually a lot busier. So there were some spots open.
Sounds like you're familiar with Webster Street.
Objection, Your Honor. Attorneys testifying.
Overruled. Sounds like a question to me.
Sounds like you're familiar with Webster Street. How many times would you say you've driven on that road?
A lot of times. I've lived here my whole life. All the restaurants are there.
You said that you arrived to Webster Street at around 5:30. What were you doing as you arrived?
So as I was getting closer, I slowed down to look for a spot. And that's when I saw Nat ahead of me and to my right, like right in my line of sight. So then as I got closer, I pulled in. I was about to pull in, and that's when the motorcycle just pulled out right in front of me. And I slammed on my brakes, but I just couldn't stop to avoid it. I tried.
All right, Ms. Ryan, let's break that down. Would creating a demonstrative of the events of September 4th assist you in explaining to the jury how the incident occurred?
Yes, definitely.
Your Honor, permission for the witness to utilize a demonstrative for the jury.
Any objections from the plaintiff?
Without objection, Your Honor.
All right, then you may proceed.
Ms. Ryan, could you please draw Webster Street?
Yeah, of course. So Webster Street is a 2-lane road, and there's parking on both sides of the street. I can draw it now.
And where is Montana Max's located?
Montana Max's is on the right side of Webster Street when you're driving west. I can draw Montana Max's with a little box with a little MM in it.
Thank you, Ms. Ryan. And you mentioned Nat was ahead and to your right in your line of sight. Where was she standing?
So Nat was to the left of Montana Max's. I can also draw a little MM, maybe to make a box. So MM equals Montana Max's too. And NR is my friend Nat.
Thank you, Ms. Ryan. Thank you. What happened first on September 4th?
So I turned right and I was driving west on Webster, and that's when I was getting closer to the restaurant.
Can you please indicate what it looked like as you began to drive on Webster Street?
Yeah, I can draw my car as like a little box with my initials in it, DR, and I can put DR equals me, Darren Ryan.
And as you were driving down Webster, what happened next?
So I was getting closer to Montana Max's, and I slowed down, put my blinker on because I was going to park in an empty spot.
Can you please draw where your car was as you were approaching?
Yeah, so my car, I can make my car move forward like that. Same box with my initials.
Where was the spot that you were attempting to pull into?
So it was ahead of me and to my right. I can draw a little X as to where about the spot was. And then in that little box I was writing, and I can write X equals parking spot.
Thank you. And what happened as you were about to pull into that spot you just marked?
Well, that's just when the motorcycle just darted out right in front of me, and I just couldn't stop.
Okay, let's take a step back for a second. Where did that motorcycle that you said darted in front of you come from?
It came from this spot right here. I can draw about where it was, a little rectangle.
You heard Mr. Stork testify that you were distracted as you approached here. Is that true?
No, not at all. I was just trying to park. I wasn't distracted or anything.
You heard Mr. Stork testify that you were waving as you approached. Is that true?
No, not at all. I wasn't waving. I had my hands on the wheel. I was just trying to park. I didn't wave.
What happened next, Miss Ryan?
That's when the motorcycle just pulled out so quickly.
Can you please indicate what that looks like?
Yeah, so when the motorcycle pulled out, I can redraw what that looked like. And that's what it looked like when it just darted out in front of me.
Your Honor, defense offers this image as defense exhibit A2.
Any objections?
No objections.
All right, then we'll admit it as exhibit A2.
What happened after the plaintiff darted in front of you?
Well, I slammed on my brakes so hard, but everything just happened so quickly. I just I just couldn't avoid it because it just came out so fast, and that's when we ended up colliding.
Can you indicate where you ended up after you collided?
Yeah, so we were both in the middle of the street after it pulled out, and I can show what that looked like.
Let the record reflect the witness has drawn her vehicle again with a rectangle and a DR in the middle of the road with the plaintiff's motorcycle denoted with a rectangle in front of her vehicle. At this time, defense offers this image as defense exhibit A3.
Any objections?
No objection.
All right, A3 will be admitted as well.
What, if anything, did you notice about the person who darted out in front of you?
Well, I noticed that the person that just pulled out wasn't wearing a helmet.
Permission to deconstruct the demonstrative.
You can take it down.
What happened after the incident, Ms. Ryan?
Well, the police came after, and then I went home, and I ended up going to the hospital the next day.
Without going into detail, did you sustain injuries as a result of the collision?
Yeah, I had to slam on my brakes so hard that I jerked forward like that and like that. And I did sustain injuries because of it.
Let the record reflect the witness indicated the manner in which she jammed on her brakes caused her body to jolt forward and then jolt backwards. Nothing further, Your Honor.
All right, cross-examination.
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Miss Ryan.
Good afternoon.
Can you see and hear me okay on your screen?
I can.
I'd like to start by talking about how much experience you had behind the wheel of your car. Now, you got your driver's license a few months before your 17th birthday.
Yes, I did.
And on the day of this accident, you were 18, right?
I was.
So you'd been driving for a little over a year at that point.
Yeah, a little over a year, I would say so.
I'd like to ask about where your attention was on the day of the accident. Now that was September 4th of 2017, right?
It was.
And you made plans that evening to hang out with your friend Nat.
Yep, we were hanging out.
Now Nat was supposed to introduce you to a potential employer.
That's what she said. She wanted me to meet some friend of hers about a job, but I wasn't really interested in it.
Now you say you weren't interested, ma'am, but to be clear, at that time, you lived with your grandmother.
I was taking care of her, yeah.
So you lived with her,
Yes.
rent-free.
Yeah, I didn't have to pay rent when I was living with my grandma.
But at the time of this accident, well, you were about to move out on your own.
I was hoping to, but I was still living with her.
Right? You were hoping to move out on your own, right?
Hoping to, but I was still living with her.
And while you were still living with her, hoping to move out on your own, you were actually hunting for jobs.
Objection, relevance?
Counsel,
Your Honor, this goes to the witness's mindset on the day of the accident. It's our theory of the case that she was distracted and she looked off the road and caused this accident. So this goes to that mindset.
well, we're talking about the relevance of hunting for jobs.
Yes, Your Honor. Because this witness was hunting for jobs and unemployed, at that time, she would have had the motivation, she would have had the incentive to get to that interview. And that would have gone to her being worried about being late and rushing. So it goes to what she was actually doing and her culpability in this accident.
All right, brief response. Why is that not relevant? Because it sounds relevant to me.
Your Honor, hunting for jobs is irrelevant to whether or not the cause of the accident on September 4th. She just stated that she is uninterested in getting a job. Therefore, it is irrelevant that there was this hunt for a job, because that is not what the witness just testified to.
Yeah, she said she was not particularly interested in a job, but if she was in fact actively hunting for jobs, I think that would be relevant. So the objection's overruled. You can proceed, Mr. Trevisani.
Miss Ryan, so the jury understands at that time, you were job hunting, right?
I wouldn't necessarily say I was job hunting. I was just really focusing on my schoolwork at the time. I mean, I was kind of looking, but I was just focusing on school.
Specifically, ma'am, you couldn't find any jobs that paid more than minimum wage, right?
Objection, relevance?
Your Honor, may I respond?
You may.
Your Honor, this witness time and time again has tried to portray that she didn't care about this meeting. This goes to rebut that. It shows that she did have this incentive. It's relevant to today's case.
May I be heard, Your Honor?
You may.
I'm unsure what the payment of these alleged jobs is relevant to. We've established that there's a job hunt, okay, but I don't see the monetary value of these jobs to be relevant.
I'll allow it. I'll give you a little leeway, Mr. Trevisani, but let's not belabor the point on minimum wage versus other wage jobs.
Understood, Your Honor. I just need a yes or a no, Miss Ryan. At that time, you couldn't find any jobs that paid more than minimum wage, right?
Not specifically, no.
Okay. Now, you knew that that meeting with Nat and this potential employer had to start at 5 p.m.
That's what Nat said.
You didn't leave your home until 5:10 p.m., right?
Exactly.
From your house to the restaurant, it's about 20 minutes, right?
About 20 minutes. It depends on the day.
So that would have put you there that day at around 5:30.
Yep, around 5:30.
Ma'am, you had been told that this potential employer had to leave at 5:30.
Yeah, but it wasn't like a job interview or anything. We were just hanging out.
5:30 sharp, right, Miss Ryan?
That's for that friend, but we were just hanging out.
I understand that you were just hanging out, but to answer my question, you knew that this person had to leave at 5:30 sharp, right?
That's what Nat said.
The truth is, ma'am, you were concerned that you were about to miss out on a job opportunity,
Wasn't a major concern.
but a concern.
Not a big one.
All right, Miss Ryan, let's talk about what you did when you got to Webster Street. Now, when you got to Webster, you wanted to park your car.
I did.
You saw a parking spot next to a motorcycle, right?
Yeah, the parking spot was in front of where the motorcycle was
A parked motorcycle, correct?
at the time.
So then, just to be clear about what you remember from that time, your windows were down, right?
Yeah, they were.
You don't remember ever hearing a motorcycle revving that day, do you?
Not specifically.
You can't specifically tell the jury you heard the engine of a motorcycle.
Not specifically. I'm sorry.
That's fine. Now I want to focus on who caused this accident. Now you'd agree that when you're behind the wheel of your car, it's important to keep your eyes on the road.
Very important.
If you don't keep your eyes on the road, that can be dangerous.
Yes.
But that day, as you began to park, there was a time where your eyes weren't on the road.
No, that's not true.
Well, then let's break it down for the jury, because you actually looked at two different people that were standing on the sidewalk,
Yeah, they were both in my line of sight.
right? One of those people was someone you didn't recognize.
That's correct.
They appeared to be walking in the other direction.
Yeah, that one person, yeah.
And in addition to that person, you also saw your friend, Miss Romanoff.
Yeah, my line of sight.
You saw Miss Romanoff coming towards you.
Coming towards me? What do you mean?
You saw your friend standing on the sidewalk looking towards you, right?
I think she might have been looking in my direction, yeah.
Well, you know from your perspective that she appeared to look in your direction, right?
Yeah, I said that.
And the reason you know that, ma'am, is because when she looked at you, you looked right back at her.
No, she was in my line of sight. I was able to see her when I was driving.
Now, when she was looking at you, when you were looking back at her, when you were looking at this other stranger, all of that happened before you hit Miss Gray.
Before we collided, yeah, but everyone was in my line of sight. I was just driving trying to park.
To be clear, all of that happened before this collision, right, ma'am?
Yeah.
Thank you, Ms. Ryan. Your Honor, we have no further questions at this time.
All right, redirect.
Yes, briefly, Your Honor. Ms. Ryan, why weren't you interested in Nat's potential job opportunity for you?
Well, I wasn't really focused on a job. I was just trying to take care of my grandma and work on school. So I wasn't really interested in any type of job, really.
So why weren't you in a rush on September 4th?
Because we were all just hanging out. Like, I didn't think of it as any big deal. We were just hanging out.
And you were asked a lot about what you saw on September 4th. Did any of what you saw affect withdrawn? Why couldn't you stop in time when the motorcycle pulled out in front of you?
Well, it just pulled out right in front of me. I was just driving, trying to park.
Nothing further, Your Honor.
All right, thank you. Ms. Ryan, you may step down. Do the defendants have another witness?
Yes, Your Honor. Defense calls Nat Romanov.
All right. Ms. Romanoff, step forward and be sworn.
Raise your right hand. Do you affirm the testimony you are about to give is the truth and nothing but the truth?
Yes, I do.
All right, Ms. Rubino, you may proceed.
Yes, Your Honor. Good evening, Ms. Romanov. Can you please introduce yourself to the jury?
Yes. Hello, my name is Nat Romanov.
Ms. Romanov, what do you do for work?
Right now I'm a student, actually. I'm finishing my last year at Steelton Tech currently.
How do you know Darren Ryan?
So before I went to Steelton Tech, I actually started at Steelton Community College for a bit to save money. And I met Darren there. We met at orientation. We ended up living together for a bit.
How close were you and Ms. Ryan after you changed schools?
We remained close. You know, Darren was always a good friend, so we stayed close.
Now, I want to talk about September 4th. What happened that day?
So September 4th was actually Labor Day. We didn't have class, so a bunch of us decided to try out this new restaurant in town, Montana Max's. I invited Darren. You know, I figured she'd want to come hang out. And I had a friend that I thought she might get along with, so.
What time did you tell Darren to meet you at Montana Max's?
I said 5 because my friend had to leave around 5:30.
Did Darren get there at 5?
No, not at 5, but I mean, it wasn't a big deal.
Why not?
I mean, it was Labor Day. We didn't have class. The main reason I invited Darren was to hang out, eat something besides campus food. It wasn't like a formal interview or anything.
Now, since your friend had to leave at 5:30, what did you do at that point?
Yeah, so at 5:30, like you said, he had to go. So I walked him out of Montana Max's.
What did you see when you were outside of Montana Max's?
I had walked out of Montana Max's like a couple steps down the sidewalk, and that's actually when I saw Darren start to drive down Webster Street.
When you saw Darren, what did you do?
I mean, I saw him, so I saw her, so I waved quickly.
And what happened while you were looking at Darren's car?
So I waved. I mean, it looked like she looked in my direction. I was also standing right outside Montana Max's, but while I was looking at her, I heard this really loud engine rev. And then immediately after, I was kind of looking to see where it came from, and I heard this even louder screech. And that's when I realized it was coming from behind me. So I turned around and I saw the incident in the street, and it was hard to watch.
Now, you're saying you heard the revving and screeching. How do you know where these noises were coming from?
Well, I don't know for sure, actually. I just know it wasn't coming from Darren's car, the revving, because then I looked around and I couldn't really tell. And then I turned around, and that's when I saw Darren's car in the street and the motorcycle directly in front of her car.
Now, when you say they were in the street, was this close to the parking spots?
Not really, no. I mean, Darren's car was consistent with where she had been driving in the lane. Not really close to the spots, no.
Thank you, Ms. Romanov. No further questions.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good afternoon.
Hello.
Can you see and hear me okay?
Again,
I want to start off by talking about your relationship with the defendant. The
Okay.
two of you are friends, right?
yes, we are.
Good friends.
Yeah.
In fact, the two of you used to live together, right?
Yeah, like I mentioned before, I went to Steelton Tech. I started at community college and we lived together there.
While you lived together, well, there were some months where you couldn't make rent, right?
Sometimes money was tight. That's why I started at community college.
When money was tight, when you couldn't make rent, the defendant, she'd pay your rent for you, right?
She did help out with that. It was really nice.
Well, not just help out, she'd pay your rent for you, right?
Objection, relevance.
Counsel,
Your Honor, this goes to bias.
overruled.
The defendant paid your rent for you, right?
Yeah, that's what I mean by help out.
Never asked you to pay her back, did she?
Not really, no. She was good about that.
You feel like you owe the defendant, don't you?
Objection, vague.
Overruled.
I
Ms.
mean,
Romanov, you feel like you owe the defendant a lot, don't you?
yeah, I mean, she helped me, so she was always a good friend.
Let's talk about who caused this accident, because you were there that day, right?
I was, yeah.
You were on Webster Street?
On the sidewalk, not on the street.
Oh, right. So you were on the sidewalk, but you had a clear view of the street, right?
Parts of it at different times.
Well, at one time, you saw the defendant drive her car down the road.
Yes, I walked out with my friend and then I saw her drive down the street.
And you know from after the accident that Miss Gray was sitting on a motorcycle, right?
From after, I mean, I never actually saw that, but after, like you said, yeah.
Right, because before the accident, you never saw that motorcycle move out into the road, did you?
No, like I just said, I didn't. I only saw Darren's car and then the motorcycle, like you said, after.
Right, so you never saw the motorcycle move at all?
Actually move? No, I just didn't see the my motorcycle at all until after, so no.
Oh, so before the crash itself, you never saw that motorcycle?
Objection, asked and answered.
Your Honor, I haven't asked this question. I've asked whether she's seen the motorcycle move. Now I'm clarifying as to whether she saw the motorcycle's even presence.
Your Honor, it's clear that the witness has stated that she only saw the motorcycle after the collision had occurred. She's already testified to this fact.
I agree. I think she has. I think you should move on, Mr. Eyers.
Yes, you're wrong. Now, let's talk about why this accident happened. That day, you'd set up a meeting between the defendant and a potential employer, right?
I mean, I wouldn't call it a meeting. It wasn't like a formal interview. I thought they'd get along.
Well, you arranged for the two of them to both be there, right?
Mainly to hang out, but yeah, I figured they'd get along that way as well.
You arranged for the two of them to meet.
Objection, asked and answered.
Overruled. I don't think she's exactly answered it.
Yes, I did for them to meet.
Sorry, was that a yes?
Yeah, I'm saying I did arrange for them to meet. They were going to hang out and potentially talk about work.
And now you'd arranged for the defendant and this potential employer to meet up at a restaurant, right?
Yes.
Around 5 o'clock.
Yes, Montana Max is around 5, yes.
But the defendant was late, right?
She did not get there by 5.
Well, at 5 o'clock, you and this potential employer, you're both there at the restaurant, right?
Yes.
But the defendant wasn't there.
No.
At 5:15, the defendant still not there.
No, like I said, I only saw her at 5:30 when I walked out and she was driving. So no.
Right, so at 5:30, the defendant didn't walk into the restaurant.
Unfortunately, she never got the opportunity to.
Well, at 5:30, that's when that potential employer got up and left, right?
I was going out with him.
So that's a yes. That's when that potential employer got up and left.
Yeah, with me.
And you left with them?
Yes, with me.
And as you exit the restaurant, well, that's when you see the defendant's car, right?
Yes, as I've said.
It's coming down the road.
Yes, she was driving.
You can see that she's the one behind the wheel.
Yes, she was driving.
You tried to get the defendant's attention, didn't you?
I waved at her.
Right, you waved at the defendant.
I did.
The defendant appeared to look in your direction, right?
It looked to me like she looked in my direction. I was standing outside, but to me it looked like she looked in my direction.
Right, but you weren't standing in the middle of the road, were you?
No, I was on the sidewalk outside Montana Max's.
Right, so you weren't in that parking area on the side of the street either.
No.
You were off the road.
You mean the sidewalk?
Yes, you were off the road, right?
Off the road means the sidewalk?
Objection asked and answered. This witness has already established where she was standing when she saw the car.
Your Honor, I'm just trying to clarify.
I understand, Mr. Eyers, and I think you're entitled to ask the question, were you off the road? So go ahead.
Ms. Romanov, you were off the road.
Yes, on the sidewalk.
So when the defendant seemed to look at you, it seemed to you like she took her eyes off the road.
I mean, sure, briefly, but like I said, it looked to me like she looked in my direction.
So that's a yes.
Yeah, sure, briefly.
No further questions.
Redirect.
Yes, Your Honor. Mr. Romanov, on cross, you were asked about this meeting at Montana Max's. Was this a formal interview?
No, not at all. It was really just to hang out. I mean, we just wanted to get something besides campus food, and I thought that they would get to know each other and meet, but they could have met at any time.
Now, after you heard the revving and the screeching, how many vehicles did you see when you turned around?
Just those two, just Aaron's car and the motorcycle.
Thank you, Mr. Romanov. I have no further questions, Your Honor. I ask that this witness be excused.
You'll be excused, Ms. Romanoff. Thank you. Good luck in DC.
Thank you, Your Honor.
And defense rests.
All right. Are we ready to proceed to closings, or do either side have motions?
Your Honor, defense has no further witnesses, but before going to closing arguments, we would like to renew our motion for judgment as a matter of law pursuant to Rule 50. May I
And
proceed?
we'll deny that pursuant to Rule 50. I understand you have to renew it.
Yes, Your Honor.
Do the plaintiffs have any motions?
The plaintiff has no motions, Your Honor. We request a brief 2 to 3 minute recess prior to closing arguments, as well as a time check.
Yes, let's get a time check first.
Okay, the plaintiffs have 23 minutes and 6 seconds left.
Thank you.
May we also have a time check for the defense?
Yes, 1 second. The defendants have 21 minutes and 44 seconds left.
Thank you.
All right, we will take 5 minutes. We'll be back at 6:26. And I'm sure based on what I've seen, we will not need the 21 or the 23 minutes, but just in case you have a lot of time left. So we'll see you all at 6:26. Thank you.
Thank you.
All right, is everyone back? If you're not here, just say yes.
Defense is back, Your Honor.
All right, how about the plaintiffs?
Yes, we're back, Your Honor.
And are the scoring judges back? That would be important too. Bailiff, Madam Bailiff, can you tell?
I see one is shaking her head. Yes. Yes, I see the other one. Yes, 3. Okay, 3. Is that
Okay.
everyone?
That's everyone. 3 is what we need. All right. We'll now proceed with closings. Plaintiff, you have the floor first.
Thank you, Your Honor.
You're welcome.
Your Honor, before I proceed, may we have permission to display any demonstratives that were created during trial, as well as portions of the verdict sheet and the jury instructions?
Well, certainly the verdict sheet and the jury instructions are fair game, and you have communicated with the defense on the demonstratives, I presume?
Yes, Your Honor. Both sides have sent their demonstratives to the other party.
And no one has any objection to the use of them during closings?
No, Your
Certainly
Honor.
none from the plaintiff, Your Honor.
All right, then we don't need to ask permission. Just go right ahead and do it.
Thank you.
All right, you may begin.
May it please the court. When a child starts Little League, what does their coach tell them? Keep your eye on the ball. When that child goes to middle school and they're passing notes to a mate in the back of the classroom, what does their teacher say? Hey, you two, eyes up front. But when that child becomes a teenager and their mum hands them the keys for the very first time as they walk out the door, what does she remind them? Keep your eyes on the road. Members of the jury, we are here today because the defendant forgot that first rule of driving. Always keep your eyes on the road. Now, as the plaintiff today, we had the burden of proof. But our burden, it wasn't the criminal one you hear about in television or film. We didn't have to prove anything beyond a reasonable doubt. Our burden was what's called a preponderance of the evidence, more likely than not. That means that we had to show that more likely than not, the defendant was negligent. And more likely than not, that negligence is what caused Miss Gray's injuries. We met that burden today with 3 simple facts. Miss Gray was parked. The defendant took her eyes off the road. And the defendant ran into Miss Gray. So let's take those one at a time. Fact number 1, Miss Gray was parked. Now, you heard from 3 eyewitnesses today to the accident. And I say 3 because the 4th witness we heard from, Miss Romanov, well, she admitted. She didn't see the accident. So let's take a look at what the people who actually saw this accident told us. Miss Gray told you that motorcycle was parked. Mr. Stork told you that motorcycle was parked. The defense, they did everything they could today to try to convince you that that motorcycle had gone out onto Webster Street. Because they had to. If the defendant ran into a parked motorcycle, well, then there is no defense. They tried to tell you, oh, well, Miss Gray, she's driven without a license before. That's not true. Sure, she's practiced in parking lots after work, but there's no evidence she'd ever taken that motorcycle out on the road. They tried to show you a diagram. They showed, look at the angles. Look at the angle that this motorcycle is pointing. There's no way it could have gotten here. It was in the road. They even asked Miss Gray about it, and she said, look, I didn't hear anything, or I didn't see anything because I was unconscious. But sure, I've been told it was in the road. But could that bike have ended up in the road because, well, it ricocheted off the curb and ended up in the street? The fact is, we don't know. Now, the defense, they want to focus on inconsistencies that they've said arose in our case, but what inconsistencies are they talking about? Both Miss Gray and Mr. Stork told you, well, Mr. Stork told you, well, she turned on the bike. Miss Gray said, I don't remember. They both said she'd practiced in parking lots. They both said that Miss Gray was the one on the sidewalk first. Mr. Stork said, yeah, I came from the bar. And Miss Gray, she did say that Mr. Stork drove up on a bike, but this accident happened more than 3 years ago. How likely are we to remember who arrived first or how they got there? But they remember what's important. Both Miss Gray and Mr. Stork, they told you the same thing and they showed you the same thing. At the time of the accident, that motorcycle was parked. But if the defense wants to talk about inconsistencies, we can talk about inconsistencies. Because Miss Romanov told you, well, I heard a revving noise. But the defendant, who was driving with her windows down, said, I didn't hear a revving noise. Miss Romanov said, oh, well, I waved at the defendant. But the defendant said, well, I never saw her wave. The defendant told you that she could see the bike and she could see Miss Romanov because they were all in the same line of sight. But I want to show you the diagram that they themselves created of where everybody was just before this accident happened. Miss Romanov, she's behind the defendant. That motorcycle, it's in front of the defendant. That's an inconsistency that matters, members of the jury. You see, the thing is, there's only one witness we heard from today who saw this accident and told you that that motorcycle moved. And it was the defendant. That means that the only person who got on the stand today and testified, I saw that motorcycle move, is the person being sued for running into it. We have shown that it is more likely than not that motorcycle was parked. Which might leave some of you with the question, why or how does somebody hit a parked motorcycle? That brings us to fact number 2. The defendant took her eyes off the road. See, that day, the defendant was in a rush. Her ETA was 5:30, but that potential employer she was meant to be meeting had to leave at 5:30. Now, the defendant, she did what she could today to try to say, oh, she didn't care. It was just a hangout. She wasn't really concerned. But we know that's not true. Because we know the defendant was trying to move out, was unemployed, and needed a way to pay rent. The defendant said she wasn't that concerned, but when my co-counsel pressed her, she admitted. Maybe she wouldn't call it job hunting, but she couldn't find a job that paid her enough. She was concerned. And if she was concerned before she even arrived on Webster Street that day, well, imagine the defendant's panic as she turned onto the road, because remember what Miss Romanov told us. She told us that the moment she saw the defendant's car coming, well, that was the moment she stepped outside to leave with that potential employer. The defendant knew she had to park immediately. And that's when she took her eyes off the road. And we know she took her eyes off the road because her own good friend, Miss Romanov, told us she did. They tried to say, well, it was only a glance, it was only for a moment. Members of the jury, when you are behind the wheel of a car, a moment is all it takes. But in this case, it wasn't just a moment. Because the defendant took her eyes off the road long enough to see someone that she didn't recognize, to see them start to walk away, and then to see her friend, looking towards her, to wave at her friend, to watch her friend wave back, to make eye contact with her friend. You see, every moment that the defendant was focusing on what's going on the sidewalk, well, that's a moment that she's not paying attention to the young woman parked on her motorcycle. Fact number 3. The defendant ran into Miss Gray. And this is the one thing that every witness today agreed on. They wanted to call it the two vehicles colliding, but everyone agrees that it was the defendant's car that hit Miss Gray. And not just hit from behind. The last thing that Miss Gray saw was that car rushing towards her. And the next thing she remembers is waking up in a hospital. I want to show you the jury verdict form. Question 1 will ask you, was the defendant negligent? As the judge will explain, negligence is when a person fails to act as a reasonable person would under the circumstances. A reasonable person, they don't take their eyes off the road. A reasonable person doesn't hit a parked motorcycle. You can mark yes to question 1. The defendant was negligent. Now, question 2 asks, was the defendant's negligence the proximate cause of Miss Gray's injuries? Proximate cause has 2 parts. The first part is whether Miss Gray would have been injured but for the defendant's negligence. Certainly, if Miss Gray hadn't been hit, she wouldn't be hurt. The second part of proximate cause is whether those injuries are foreseeable. Members of the jury, it's foreseeable that if you take your eyes off the road, you could hurt somebody. It's foreseeable that if you hit a parked motorcycle, you could hurt somebody. You can mark yes to question 2. The defendant's negligence was the proximate cause of Miss Gray's injuries. Question 3, it asks, was Miss Gray negligent? Members of the jury, she was parked. You can mark no. Miss Gray, she wasn't negligent. And if that's how you answer those first 3 questions, then you're done. When a child takes his eye off the ball, he could strike out. If a child takes his eyes off the teacher at the front of the classroom, he could end up with a phone call home. But when a driver takes her eyes off the road, we've seen what can happen. We ask that you find the defendant liable for Miss Gray's injuries because the defendant broke the first rule of driving. Keep your eyes on the road. Thank you.
Thank you, Mr. Eyers. Counsel.
Before I begin, I just want to make sure you can hear and see me okay.
I can.
May I proceed, Your Honor?
You may, Ms. Guidarelli. Is that right?
Nicely done.
I've been working on it all trial.
I don't get that right a lot. Thank you. All right. That story, that plaintiff tried to tell you over and over during today's trial that Darren Ryan hit a parked motorcycle does not make any sense. Members of the jury, at this point, you have heard from all of the witnesses, and now it's your job to decide what evidence you heard is believable and what is unbelievable. The choices, they're simple. Do you believe that Miss Ryan just ran her car right into plaintiff's motorcycle while it was parked, not moving? Or do you believe Carson Gray got on her motorcycle, put the keys in the ignition, kicked up the kickstand, put that motorcycle into gear, and darted out into traffic without looking, without a helmet, and without a license? When thinking about that choice, when you go into deliberations, I want you to remember what my co-counsel asked you all at the very beginning of this trial. Do not check your common sense at the door. Are we to believe that it was just a coincidence that plaintiff's next road test was the very next day? Was it a coincidence that Miss Gray, despite having a car with her at work, decided to walk 30 minutes to Montana Max's that day? Was it a coincidence that that friend she was meeting, Mr. Stork, also just happened to have Miss Gray's motorcycle that Miss Gray was going to use the next day for her exam? And was it a coincidence that Mr. Stork, the only other person Miss Gray allowed to ride her motorcycle, already had 5 or more drinks before the plaintiff even got there? Are we to believe that plaintiff got on her motorcycle, engine running, hands on the handlebars on a beautiful Labor Day with Tony Stork drunk and had no intent to drive? Is that believable? Members of the jury, as you think about that question, ask yourselves, what was the plaintiff's plan? What we do know for sure and has gone undisputed today is that the plaintiff failed her first licensing exam by 1 point. It's also gone undisputed today that plaintiff's next licensing exam was scheduled for the next day. And it's undisputed that Miss Gray practiced for that next exam. So it's undisputed today that she has in fact driven without a license. And it's undisputed that Mr. Stork had that motorcycle that plaintiff needed for her next road test. And Mr. Stork, that one friend she trusted with her motorcycle, was at Montana Max's with that motorcycle, and he was drunk. So again, I ask you, what was the plan? Now, there are 2 possible scenarios that are actually believable. First, Miss Gray always intended to drive her motorcycle, which is why Miss Gray walked, why Mr. Stork brought the motorcycle, and why Mr. Stork drank the way he did. Because Mr. Stork knew Miss Gray was going to drive that motorcycle home because that was the plan all along. Or maybe you believe, despite the odds, that it was a coincidence that Miss Gray walked, that Miss Gray and Mr. Stork set up this meeting, and Miss Gray had no idea Mr. Stork was bringing her motorcycle with him. But I want you to think about the second scenario with me. So Miss Gray, she shows up to Montana Max's and she sees Mr. Stork, and she denied knowing that Mr. Stork was drinking, but Mr. Stork admitted on the stand that at this point, he already had at least 5 drinks. So then Miss Gray, she sees her motorcycle and she gets nervous, and she gets on that motorcycle, not to get mentally prepared or excited for her exam like she told you. She got on that motorcycle because she was worried. She was worried she wouldn't be able to take her licensing exam because Mr. Stork couldn't drive that motorcycle home for her. So Miss Gray got on her motorcycle so she could drive herself and that motorcycle she needed home. Now, I can't tell you exactly what went through Miss Gray's mind, whether she went to Montana Max's with the intention to drive that motorcycle home, or whether upon seeing Mr. Stork drinking, she then decided to take matters into her own hands and drive that motorcycle she needed home. no matter which way it happened, we end up in the same scenario. Miss Gray sitting unlicensed on a running motorcycle with every intention of driving it. And that's exactly what she did. She kicked up the kickstand, revved the engine, and darted out right in front of Miss Ryan. You heard from Miss Ryan, who told you what really happened that day, and she drew it out for you. She was driving to Montana Max's to meet her friend. Miss Romanoff, who you heard from today, wanted Miss Ryan to meet her friend earlier in the day. Plaintiff said Miss Ryan was rushing, but you saw that meeting between Miss Romanoff's friend and Miss Ryan, that wasn't a priority for Miss Ryan, who at the time was more concerned with school and taking care of her grandmother than a job hunt. She was living at home. There was no rent to pay. There was no bills to pay. She was uninterested in a job. Miss Ryan wasn't rushing to Montana Max's to meet that meeting. As she turned on Webster Street, you saw today that Miss Romanoff was right on the sidewalk as Miss Ryan was pulling up. Now, the plaintiff's whole case relies on the fact that Miss Ryan was distracted. But what you heard was Miss Ryan was paying attention, eyes on the road, getting ready to park, when out of nowhere, Miss Gray darted out so quickly, it was just too late to stop. Miss Ryan slammed on her brakes, but she could not avoid hitting Miss Gray. Miss Romanoff, she confirmed what Miss Ryan told you. Miss Romanoff was there in front of Montana Max's, and while she did not see the collision, and we're not saying she did see Miss Ryan driving towards the parking spot. And as Miss Romanoff was turned around, she heard the revving of an engine, followed by the screeching of tires. And as she turned back around, she saw Miss Ryan's car and plaintiff's motorcycle in the middle of the road. There was no evidence that the defendant was distracted. Miss Romanoff told you that Miss Ryan briefly looked in her direction while Miss Romanoff was waving, but Miss Ryan did not wave back. Miss Ryan told you that she saw Miss Romanoff in her line of vision as she was slowing down, getting ready to park. Plaintiff's second point today was that Miss Ryan caused this accident because she was looking at her friend Nat. But in fact, you saw that as she was about to park, she had already moved past Miss Romanoff, past that alleged distraction. Now, plaintiff couldn't speak to what Miss Ryan was doing as she was approaching the front of Montana Max's. So you're left with the words of Mr. Stork, the person who has been plaintiff's best friend since middle school, and the person who was impaired by 5 or more drinks at the time of the collision. Now, you heard my co-counsel and I questioned both the plaintiff and Mr. Stork about what happened that day. And it was a bit confusing because we heard 2 very different versions of the facts. Plaintiff swore that she was the one to arrive at the bar first and actually watched Mr. Stork pull up on her motorcycle. Mr. Stork said there's no way that could have happened because he had been inside Montana Max's for hours drinking, and he came out when the plaintiff arrived. Plaintiff also testified that when she decided to get on this motorcycle, her motorcycle was already on, but she couldn't remember who turned it on. But Mr. Stork was sure that it was plaintiff who took those keys and turned the ignition on. Plaintiff's witnesses cannot get their story straight because they don't even believe it. You saw both witnesses today on the stand could not answer any questions. The most frequent line out of Miss Gray's mouth was, "I don't remember." She couldn't remember if Mr. Stork, who she works with, worked that day. She couldn't remember who even turned her motorcycle on. And Mr. Stork qualified every single one of his answers. Opposing counsel on his closing said that this accident was 3 years ago. Who can remember everything? Opposing counsel said plaintiff's witnesses remember what's important. Do they remember what's important, or do they remember what's convenient? Do they selectively only remember the facts that support their unbelievable story? Ms. Gray told us today that she was in advertising, and all day plaintiff has been trying to sell you this unbelievable story. Now, I'm not able to show you video reenactments of this incident, but again, I want you all to think about this with me. if Darren Ryan was driving on Webster, slowing down and planning to park in the space in front of the motorcycle, and plaintiff's motorcycle was really parked and never moved, where would those vehicles have ended up? I'll tell you where they wouldn't have ended. They wouldn't have ended up in the middle of Webster Street, but that's exactly where they ended. The motorcycle didn't end up in the parking spot where Darren Ryan was planning to park. It didn't end up on the sidewalk. Mr. Stork, who was standing right next to the motorcycle, didn't say he was hit or had to jump out of the way. And while we're talking again about Mr. Stork, you heard plaintiff testify to what Mr. Stork said right before the impact. Now, at first, Ms. Gray was only willing to tell you a part of Mr. Stork's statement, but then she was willing to tell you that Mr. Stork said, "Hey, what are you doing?" Now, Ms. Gray said that that comment was directed to Ms. Ryan behind her. But if that car was really about to plow into a parked motorcycle, would Mr. Stork really just have said, "Hey, what are you doing?" Or if a car was coming directly towards his friend, said, "Carson, watch out, look out, get out of the way." He said none of those things. So was that comment really directed at Ms. Ryan? Or was Mr. Stork reacting to watching plaintiff kick up the kickstand, rev the engine, and start to pull out of that spot? Whichever way you view Mr. Stork's comment, the facts remain that the laws of physics didn't cease to exist on Webster Street on September 4th. There's been no dispute today that after the collision, Ms. Ryan's car remained in the street. To believe plaintiff's story, you'll need to accept that when Ms. Ryan's car collided with plaintiff's motorcycle in that parking spot, her car magically bounced back into the middle of the street. That is simply unbelievable. Plaintiff's motorcycle also ended up directly in line with Ms. Ryan's car in the middle of the street. Plaintiff said that she thinks that her motorcycle ended up in the road, and Mr. Stork confirmed that the motorcycle did go towards the road. And both defense witnesses confirmed that the end location was the middle of the street. Here are the 2 points of impact presented by the parties. Plaintiff refused to show you the end location of both vehicles. Mr. Stork, who saw the whole thing, refused to tell you where they ended up. Now, after seeing the end location and thinking about everything you have been presented with today, what do you believe is more likely? Did plaintiff get hit while parked? Or did the plaintiff dart out in front of Ms. Ryan? It is simple common sense. Do not let the plaintiff distract you with her unbelievable story. All trial, plaintiffs talked about the first rule of the road. Keep your eyes on the road. But Miss Gray, she didn't look at all. Miss Gray, who got on her running motorcycle, kicked up the kickstand and pulled out into the path of Miss Ryan without even looking. She didn't turn to look at oncoming traffic. She didn't turn on her blinker. She, without warning, pulled out of that parking space. She disregarded the first rule of the road. Miss Gray, she left Miss Ryan with no time to react. Miss Ryan's body was jerked violently by having to jam on the brakes like she's never had to jam on them before, that she suffered injury. And for this reason, we are asserting our own counterclaim. Opposing counsel spoke about a baseball game, and striking out. But this is real life. And in this real life situation, Miss Gray was only thinking about herself when she drove that motorcycle, and her reckless actions hurt someone else. Now, through everything we have presented you today, you've seen that not only was Miss Gray unlicensed, and not only were her actions unlawful, but that story she gave you today is simply unbelievable. You saw that this case was not about a late, rushing, distracted driver. In fact, you saw no evidence that Miss Ryan was distracted or late. There was no rushing, there was no waving. Rather, you saw that this case is about Miss Gray being a reckless, unlicensed, dangerous driver. Hold the plaintiff accountable for those reckless actions she took. Find her liable. Thank you.
Thank you, Ms. Guidarelli. Mr. Eyers, you have the last word.
May it please the court. Defense counsel, they asked you not to check your common sense at the door. And we agree. Because it's common sense that if you're late for a potential job offer, you could be driving distracted. It's common sense that if you're trying to wave to a friend who's behind you, you might miss the motorcycle right in front of you. It's common sense that if your eyes aren't on the road, you could cause a crash. It's common sense, members of the jury. Find the defendant liable. Thank you.
Thank you, Mr. Eyers. And thank you, everyone. Well, that concludes it. I presume that since you've done this 10 times now, you may be tired of the case, but you certainly would never know it from that presentation on both sides. This is the time for feedback, and I don't have any. I'll just give you a little words of encouragement. My name's Bob Daly, and I practice in Pittsburgh, and I teach trial advocacy. I coach trial advocacy teams, and I've coordinated AAJ regionals for 6 or 7 years. So I've seen a lot of student trial advocacy competitions, and as the scoring judge, rather as the presiding judge, I don't score, and I'm glad for that, because obviously this is the finals, and you've made it through hundreds of teams, and all I can say is that you were all very, very tremendous, and I wish you all the best going forward. You all put on a great performance today, and I'm not going to offer any feedback because it's not a whole lot I could say that would probably make a difference to you. So just know that you both were very worthy, and you both teams should be congratulated, because I know exactly what it takes to get here, and I know this is your 10th trial, and I know that you likely won 8 or 9 of the previous ones coming into this. So all the best going forward.
Thank you very much.
Thank you.
For this is Kara from AJ. For the scoring judges, can you please submit your score sheet so we can tally while you guys make your final comments, and then we'll get on here and I'll announce the runner-up for the competition and the winner. So
Kara,
thank you.
Kara,
Yes.
I submitted mine. This is Karen.
Yes, I did get you. I saw yours come in, Karen.
I just submitted mine as well.
Thanks, Chrissy. And I see Elizabeth. So if you guys have additional comments, our tally team will tally, and then once comments are done, we'll go ahead and announce the winner.
Elizabeth, Chrissy, do you have any comments?
I do, I guess, because these are the kind of cases we try every day, all day long at our firm. Oops. And Elizabeth is a relatively new lawyer in our office, and we've been working on openings. So this is a great teaching moment for Elizabeth as well. But I will say that I really liked the themes that you had. I personally hate that common sense argument, but when I can't even see your whole last name, but when Alexandria spoke with Jack, I mean, when you used Jack basically counteracted your common sense argument. I thought that was excellent. And as a plaintiff,